author, columnist, managing editor of LibertyNation.com, podcast host and conservative policy advocate.
We dismiss history at our peril.
Liberty Nation Radio with Mark Angelides.
Welcome to Liberty Nation Radio, heard coast to coast on the Radio American Network. I'm your host, Mark Angelides. On today's special edition, we're talking all things legal, from Donald Trump's legal travails to Fourth Amendment issues with squatters across the country. All this and a whole lot more on today's special show. Remember, this show is proudly sponsored by LibertyNation.com, where you can access podcasts, breaking news, analysis, and a range of biting and brilliant shows to whet your appetite for freedom and your fondness for the great American Constitution. Donald Trump appears to be in a New York state of mind, with many cases coming out of the Big Apple against him, for him, and everything in between. We're very fortunate to be joined by Liberty Nation's legal affairs editor, Scott Cosenza, who joins us for this special edition examining all things lawfare.
And fellow Billy Joel fan.
And fellow Billy Joel fan, absolutely. I mean, who isn't a Billy Joel fan?
Celebrate the man's whole catalog.
Absolutely. Apparently, he does actually ride the New York subway. I read this the other day.
Unlike Mr. Trump, by the way.
Unlike Mr. Trump. He rides the New York subway. And people look at him as though, look at you trying to look all Billy Joel. That's So that's kind of, even though they assume he's not Billy Joel. But anyway, Scott, let's talk New York. So the big news this last week was, on, I believe, Monday last week, was that the bond for Donald Trump's civil case for overinflating his assets, the appeal bond, was reduced from $450+ million down to $175 million, which is, of course, mere pocket change to Mr.
$100 million here, $100 million there.
Between friends, it's almost nothing, right? So that was the big shock there, because Letitia James, the Attorney General, who'd been bringing this case and was the pursuer of these charges, and the presenter of those charges, she was very much all over the media talking about how she's going to seize Trump's assets. And that did not work out well for her, Scott. But I guess what I really want to talk about is where this goes from now, because it may still be the crowning victory for Miss James. It may also be a bit of a win for Donald Trump, depending on how his appeals process goes. What's your initial take on the situation?
Well, I'm going to approach my analysis from somebody who doesn't think that Ms. James looked at facts and applied those facts to the law using her best judgment for how to engage in an economy of effort with her office and the citizens of the state of New York, but instead did whatever she could to, quote unquote, get Donald Trump. Okay.
That's a direct quote from Ms. James in her campaign to.
Indeed. Yeah. And so, from that perspective, I don't know that it's possible that she can do wrong or, quote unquote, lose in a sense, because she's already won by successfully frustrating Donald Trump, getting him to have to spend his time and attention and money on fighting this case, even if he eventually wins. Now, the flip side of that coin is, of course, much like the Fonnie Willis prosecution in Georgia, perhaps it's done more damage to the progressive campaign to cancel Donald Trump than it has to Donald Trump's electoral prospects. So that's all fascinating grist for the mill, I think. But she's far from kind of finished with this process. Mr. Trump, all this does is concern the appeal bond. And I wanted to make sure that we said appeal bond earlier, because people think of a bail bond, for instance, and that's not the case here. And I think we're going to touch on some arguments that might, where Trump might allude that this is an inappropriate fine. But for now, we're just talking about a civil judgment where there's no incarceration possible, and the appeal bond just is, hey, if you've got a judgment against you, the courts have ruled you are liable for a certain amount of money. This is important. This is an important feature of the law, Mark.
Yeah.
If you think about it, if you and I own a widget company and somebody sues us for, producing bad widgets, okay? And
we would never produce bad widgets. I need that out there on the airwaves.
Okay,
the widgets that Scott and I produced they'd be the best widgets ever. People tell me, Mr. President, these are the best widgets.
And we lose at a trial and are held liable for damages for producing bad widgets. and get a substantial award against us, and and it's going to be eclipse the value of the widget company. And so we decide, well, that's it. Well, there's a couple ways you can go about it. You could actually do whatever you can to satisfy that judgment and then go out of business. Or we could say, all right, we're going to have a business closing party in Bali for the next month and spend down this money renting Ferraris and private jets. And so the person who won that lawsuit would be denied their judgment because of that, if we were allowed to not post. So that's the purpose of the appeal bond, generally speaking. So anyway, yes, massive reduction. Now they're going to hear the merits of the case. So now there will be a merits claim at the appeals court covering a number of issues, including, I hope, and especially Ms. James' political motivations for her prosecution, as well as other things. And Trump could win or lose there. And then you've got the New York State highest court in the land, and New York State doesn't have the Supreme Court. It's
topsy-turvy, isn't it?
It is, yeah.
Supreme Court's the lowest, and
right. Yeah. It's called the Court of Appeals, I think, is their quote unquote Supreme Court. So Trump could win or lose there, and then if he loses, he can go then to federal court. And if the federal court takes the case, then you've got the district court, the First Circuit Court of Appeals, and then the Supreme Court. So bite and bite and bite and bite and bite at the apple for Mr. Trump to get this, continually reduced.
So the one area I really wanted to discuss on this, and you did touch on it very, very briefly, is that this is a civil case, and it is not a criminal case. However, and it was floating around my mind that the Eighth Amendment, which protects against, let's call it overzealous punishments, right?
Excessive fines.
Excessive
That's the provision
fines.
we're talking about.
Now, we did discuss this before we came on, Scott, to record, but obviously that's only for criminal fines. And
no, let me correct the record, because
please.
I'm an American lawyer and you're not an American. And
I'm not a lawyer nor an American, right?
On one of those counts, it's to your great credit, I'll say. It does prohibit excessive fines, civil fines that are government levied. And it's hilarious, Mark, because the case on point is the Tibbs case, and Justice Ruth Bader Ginsburg wrote for the unanimous court in that case. And it's only a 10-year-old case that the excessive fines prohibition contained in the Eighth Amendment has been applied by incorporation to the states. So our Bill of Rights is initially drafted as a prohibition on federal government action. And little by little, there might be one left. Each amendment has been held to protect our rights against state exercise of powers that may infringe on free speech, right to keep and bear arms, search and seizure, etc., and excessive fines. Again, written by Ruth Bader Ginsburg. And I'm laughing because the idea that Trump could win at the Supreme Court based on words that Ruth Bader Ginsburg has written down is just a little extra kind of deliciousness to those of us who, who think that
to everybody, let's be fair. Everybody loves irony, even if it's set against them.
Let me just mention the Tibbs case, some facts about it, because it might be instructive. In that case, the man had a Range Rover. It's really a pocket kind of symphony of understanding of American drug law and seizure law, this case. The guy had a workplace injury, was prescribed opioid pain medication, couldn't get off it, got addicted to it, and got a heroin habit that it developed into. He ran out of money to buy the heroin and then started selling the heroin to fund his own addiction. In that process, his father died, and he used a substantial portion of his inheritance to buy this Land Rover, and he was arrested while delivering some of the drugs with the vehicle. And somehow, according to the police, that entitles them to seize the vehicle. And he argued the maximum fine that he could have been assessed at state law was $10,000, but the vehicle was worth $40,000. And so they've essentially enriched themselves plus $30,000 more than the maximum could be. And the Supreme Court unanimously agreed both that it was excessive and that it was incorporated against the states, that Eighth Amendment protection against excessive fines that Trump is certainly going to argue about here.
So, yeah, it does seem to me that is at least one strand of a possible defense, is that this is a burdensome, excessive fine, disgorgement or fine.
Can I just say one more thing about that?
Sure.
Because you say disgorgement. So the the money judgment that he has to pay was not called a fine. So sometimes courts can assess what are called punitive damages, and just like the name suggests, it is to punish. But the bulk of the money here is in this disgorgement, which is the idea that if Donald Trump didn't misrepresent his financial picture to certain banks, then instead of lending him money at a rate of X, it would be a rate of X plus some amount. And then that's how they calculated all the money that they would owe. Now, there's no credit given, by the way, to the idea that Donald Trump could have negotiated for a different rate, or maybe not even borrowed it at all. That's not included in this calculus.
And it is worth pointing out that the banks who were allegedly defrauded here actually sought to do continued business with Donald Trump after that. Apparently,
as I wrote,
he was a whale, was the term that I heard.
As I wrote, I think in my piece on this our piece on this for LibertyNation.com, they are the most experienced mortgage bankers in the world and far more experienced and sophisticated at mortgage banking than Donald J. Trump is or was. And they called them, loans they wished, good loans, they wanted to engage in them and wished for more loans from Mr. Trump. So
this is the appeals process on this. I think unless it gets overturned at the first hurdle, I think we're in for a good long couple of years until there's a final decision on this. Does that sound about right?
I think Ms. James is going to be in office for a good while longer, so she can her and the Soros checkbook that's funding her crusades. As long as that keeps up, then yes, I suppose you're right.
We'll be back talking about New York, continuing Donald Trump's travails in the great state after this short break. Don't go anywhere. We dismiss history at our peril.
Liberty Nation Radio with Mark Angelides.
And we're back on Liberty Nation Radio, heard coast to coast in the Radio America network. And we are once again joined by Liberty Nation's legal affairs editor, Scott Cosenza. Now, earlier in the show, we were talking about the massive cash ruling against Donald Trump in New York that got slashed by about 60%. But there was another case that took place this week in New York regarding Donald Trump, and that's the one brought by Alvin Bragg, District Attorney Alvin Bragg. Scott, give us the details of what's happened this last week.
Well, this is the hush money trial, as every major media outlet seems to be calling it, whereby Donald Trump, in wishing to spare his wife and family the truth of the disclosure of his dalliance with Stormy Daniels, who had engaged a Los Angeles attorney famous for a legal version of blackmail. And so what that means is she says, I think I'm going to write my memoirs. And of course, what's going to be featured prominently in those is the night we spent together. Or you could just pay me X amount of dollars and I'll forget about the memoir. And that's what happened. And because of the payment was made under a corporate form, Mr. Bragg has been able to turn that, so far anyway, into a criminal charge against Donald Trump for, it's sort of a made-up criminal charge that is.
But by made-up criminal charge, what you mean is it's a novel application of an existing law. Is that about right? It's one of
these special applications of the law designed to get Donald Trump, quite frankly, and that's the way to focus on it. Now, that doesn't mean that it's impossible that it'll result in a criminal conviction. Any criminal charge should be taken seriously, but that is the nuts and bolts of it.
There's a few questions that
I just wanted to add this. You asked me what happened this week, and what happened this week was that the start date of the trial has been delayed now until April because the United States Department of Justice came forth with 100,000 pages or documents concerning Mr. Michael Cohen.
This is specifically what I want to address, Scott. They brought forward 100,000 individual documents that were to be entered into evidence, presumably. Otherwise, they wouldn't bring them, right?
It's important to distinguish the two groups here. The Manhattan DA's office, Mr. Bragg's office, is the one bringing the prosecution, but it was the United States Department of Justice, Joe Biden's Department of Justice, who released the documents concerning Mr. Cohen.
Okay, and so the Trump camp, they asked for a delay to go through the 100,000 documents to see what would be relevant to their particular defense or modes of defense that they were after.
Mr. Cohen is the legal way to phrase it. Yes.
Sure. And so the judge only granted till the 15th of April, which seems like quite a short time scale considering there's 100,000 documents. But I believe the argument made by the Department of Justice was that only a small portion of these are relevant. Now, Scott, this is the part that gets my liberty bone tingling here.
Right.
The people who are engaged against Donald Trump are now determining, well, this is relevant to you and this one isn't. And surely that should be up to the defense to determine which of these documents is relevant to their defense. Because, for example, if somebody were, let's say I had a nemesis, and that nemesis is sworn to destroy me. And then he said, look,
as all nemesis
that's what they do, right?
Nemesis.
That's what they do. I do have a nemesis, but I shan't name him on this particular broadcast. But then my nemesis told me that, here's all these things. You only need these ones. These are the ones that will help you defeat me. Don't look at the other ones. Don't use the other ones in court. Just use the ones that I tell you to use. It makes no sense to me. I'm sure there's a good legal reason behind it, Scott. What is that?
So a couple things. Firstly, it's not the Department of Justice. It's not Biden's Department of Justice that's saying there are only certain ones are relevant.
Sure.
That would be Bragg's office.
Who is the nemesis in this particular category. Yeah.
But the United States Department of Justice is not making any arguments. They were just the keepers of these documents. They were subpoenaed and they turned them over. And the Department of Justice, for any defendant, forgetting about Donald Trump for a moment, just for John Q. accused criminal, if the Department of Justice has information about that case, but the defendant is being prosecuted under state court, they don't have a duty to turn it over. Part of our system of justice does not include that. It's somewhat outrageous to some of us who think that, if you believe the notion that the government, it's really about justice and not winning. Okay. But sadly, that's often not the case. And we have had, Mark, decades upon decades, if not longer, of a push in America to restrict and limit the rights of defendants and increase the rights of the state. Politicians rarely get elected, even in the face of what we've seen with Donald Trump. Maybe that'll change. I hope it'll change. But on celebrating the rights of defendants against the state, most often it's tougher on crime kind of campaigns we see from all sides of the aisle. So that's the backdrop under which he's operating.
So what I really want to know is if this does go against Donald Trump for one or many of the charges, what are the appeal routes here? Because there's no way he doesn't appeal this decision.
Yes, that's right. And it'll be another battle. Does he have to present himself into custody or not? It'll be, I think it's a bit rich, first of all, just to even think that it's going to get to an actual verdict. I suggest it probably won't. I think there'll be interlocutory appeals that control it, but it's just a typical through state court and then up through the federal courts and up to maybe and possibly including the Supreme Court.
Donald Trump should get a box at the Supreme Court the way things are going at the moment, just with his name on it, and he can just sit there and see it all out. Now, we're going to be back with Scott Cosenza after this short break. Don't go anywhere. We dismiss history at our peril.
Liberty Nation Radio with Mark Angelides.
And you're back listening to Liberty Nation Radio, heard coast to coast on the Radio America Network. I'm your host, Mark Angelides. Earlier in the show, we've been talking about the trials of Donald Trump in New York City. But now I'd like to expand this and talk about rights in general, and specifically the Second Amendment, which I know is my second favorite because my favorites run sequentially. And we're joined again by Scott Cosenza, Liberty Nation's legal affairs editor. Now, Scott, you wrote a fantastic piece with some exclusive content.
You say so, Mark.
Last week.
Accept your judgment there.
You will. On fluffy bunnies. No, I'm kidding. On gun rights. And there are three big cases, all centered around Maryland. And
two are Maryland and one is next door to Maryland in West Virginia.
Yeah. And these cases, they're all quite pertinent to the Second Amendment protections of Second Amendment rights. Scott, could you give us an overview of this?
This has to do with the legacy of the Bruin decision that the Supreme Court made that really laid the foundation for most of these gun laws in the United States, in sort of red state, or rather the opposite of that, the blue state gun laws peeled back. We have a situation where there's a number of states, the minority of states now, that have kind of all these restrictions on particular guns that a person can buy, prohibitions on carrying guns, and basically a general campaign against the lawful use of firearms in their jurisdictions. New York and Maryland are both in that bucket. New Jersey shares it as well, and they're almost all in the Northeast and California. And so these cases are all relevant to those jurisdictions and the Bruin case and how the Supreme Court's going to deal with following up on it. Of the three cases, Mark, one called Bianchi v. Brown, I think, is the most important and interesting, and that is a case about Maryland and whether or not they can restrict, quote-unquote, assault weapons. Now, for those who know, assault weapons are a made-up term that politicians and anti-gunners have used to try to trick Americans into thinking that what the object being banned are fully automatic machine guns, and they're not. They're weapons that look kind of more aggressive or dangerous or whatever the adjective would be. They're known colloquially by those who like them on the internet as EBRs, or evil black rifles. So they don't have the old Elmer Fudd look to them.
If I could just point out, I remember not long ago while I was doing social media for Liberty Nation, that somebody had put a picture saying we need to ban these, and it was a tripod folded up for a camera, and it looked almost like an AR-15.
Right,
Well, obviously it didn't to anybody who knows what an AR-15 looks like, but the reactions underneath were, yes, truly evil. It just really goes to show that people really don't know very much about
Well, I can tell you too that as I bore witness to history with this, when these bans were coming on from the early 80s on, the local news stations, before the internet, and that's where most people got their news, the local television news stations would often run stories about gun control, and the B-roll or backdrop that they were showing were machine guns firing when they would talk about assault rifles. Now, whether that was ignorance or prejudice or some combination, I don't
propaganda.
know.
Let's throw that one in there.
But it was definitely not about illuminating the issue. And so, in any case, back to Bianchi v. Brown. This is a case by some Marylanders and some gun dealers who say we should be able to buy and sell guns that are bought and sold every day in Virginia and in Delaware and in Pennsylvania. Somehow in Maryland, they can't be. And that's a violation of the Second Amendment because they are regular, in common use, rather, and not especially deadly. Two of the kind of qualifications to make a firearm to be protected under the First Amendment. But what's kind of extra about this case is the Fourth Circuit Court of Appeals has had the case for years. They initially decided the issue before the Bruin case came out. Once the Bruin case came out, the Supreme Court accepted a review of this Bianchi case and immediately sent it back down to the Fourth Circuit, to the lower court for instructions to rule on it in light of the Bruin decision. That court assigned it to a 3-judge panel. That's how most cases in our circuit courts are decided, by a 3-judge panel. And here's where the dirt comes in. The speculation is that the majority of, or some significant number of judges on the Fourth Circuit Court of Appeals heard that 3-judge panel was going to issue a ruling that they did not like, a pro-gun ruling, a ruling that would have forced Maryland to respect the civil rights, the Second Amendment rights of its citizens, and stop this ban. And so what they did was they quickly intervened before that ruling could be published and said, "Oh, we're gonna hear this case in an en banc fashion." Okay, E-N, second word B-A-N-C, and it as a whole. So instead of
15 or 16 judges, right?
Well, in this case, for one of the days, there were 2 cases argued one day, and there happened to be 15 of the judges in the courtroom for that. And then the second day, the third case was argued, and there were 16 judges. That's for the Bianchi case. And During that argument, the judges revealed a staggering amount of ignorance, both of AR-15s generally, and also they discussed sending it back down to the district court for some factual findings, meaning years on now. And if I didn't complete my thought there, what I wanted to say is, before that three-judge panel could rule, they said, oh, we're going to reschedule this for en banc review. So the advocates are waiting. En banc review is something that would occur in a normal case instead of a three-judge panel, not after the completion of a three-judge panel. That's where the stink goes to high heaven in terms of thinking that the fix is in for an anti-gun ruling on this case. And so what we have, Mark, is a rare case where people are asking for, the advocates are asking for a certiorari before judgment. And this came up in the news. So many, so much chance for historical education with these political prosecutions. It came up with Donald Trump's prosecution, but it's asking the Supreme Court to not wait for the Fourth Circuit to be done, and instead to say, you've had enough time, you're not doing the right thing. We're going to take the extraordinary step of reaching down and snatching this case from you before you rule on it to make sure that the people of the Fourth Circuit and Maryland, have their rights respected. So that's pending now.
That's a fascinating case, because it seems that the group of judges, if by sending it back to a lower court for some factual clarification, what they're really trying to do is just extend the period of time for as long as humanly possible. Sure. And during that time, the Marylanders' rights are presumably being quashed. And so then it would go back to the lower courts. Then it would come back to them, at which point they would either do a three-judge panel of
well, I don't know if they can get away with
judges
that, again,
that might rule in the correct way, or they'd go for the en banc review again, at which point years could have passed, years more than have already passed already.
And Clarence Thomas retires and is replaced by an anti-gun vote.
But by Kamala Harris or Oprah Winfrey, yes, of course.
I think it's Stedman, actually, who will be.
So, yeah, this really brings to mind something that I hear a lot on let's call them the more left-leaning news outlets. Justice delayed is justice denied.
All you have to do is think of it. So many of these issues, I think, are like this. Just change the issue. Make it the right to a jury trial or the right to free speech or any of the other fundamental rights that our Bill of Rights protects. And I think it's easy for people who aren't in the gun culture to see just how awful that violation is.
So, Scott, you reached out to people involved in bringing this case forward. And what did you learn?
I spoke with David Kopel, who is one of the nation's premier kind of gun rights lawyers. And he actually wrote an amicus brief to the court arguing why they should take this case and grant certiorari before judgment. And he's just for the record, he's been quoted by the Supreme Court, or his arguments have been cited by the Supreme Court, I think seven previous decisions. So he's got the goods when it comes to speaking to the court on gun matters, and I'm sure they take his brief quite seriously, which is why I think it's an important brief. And it just echoes the same arguments about how it's a low-powered weapon. You know, one of the things, it was really shocking, Mark, to listen to. I listened to, I think, all 4.5 hours or so of the oral arguments in Richmond at the Fourth Circuit on these cases, and it was shocking the level of ignorance some of these judges had, and were likening the destructive power of the AR-15 to really a firearm with several orders of magnitude more destructive power than it has. I mean, it was just preposterous, really. The AR-15 fires the 5.56 set in metric terms, or .223 caliber round, which is a low-powered rifle round. It is among the lowest of the rifle calibers or cartridges. So to suggest that it's a high-powered rifle, this is a vestige of, I think, poor reporting on this issue for decades and decades. It's a low-powered rifle, but of course that doesn't sell newspapers or generate outrage. So.
Scott, I think it's quite important to know that, as you point out, the judges seemed quite, in the 4.5 hour hearing, it was in Richmond because it's part of the same Fourth Circuit that covers Maryland, right? But the fact that the judges don't have intimate knowledge of this. That kind of reminds me of something that happened very recently while in the Supreme Court, where Judge Ketanji Brown Jackson was almost intimating that the First Amendment, the First Amendment ruling would stop the government being able to interfere in social media. And she seemed to have a very poor understanding of what the First Amendment is. Now, surely we're at the same risk here.
Let me just stop. Let me just stop you right there and say, just to complete the thought about Mr. Coble, he provided a handy chart for the justices with bullet weights and energy and muzzle velocity, so they could see plainly what we're talking about here. So I hope that that will, kind of control the issue going forward with the Supreme Court. But to Ketanji Brown Jackson, what she said was, she seemed perplexed that one of the advocates was advancing a position whereby the government's desire to restrict free speech was somehow stymied because of the First Amendment. I am speechless because, of course, precisely that is the point of the First Amendment, to restrict government action to stop free speech. And so that's the entire point of the endeavor. And it didn't seem like a kind of a one-off or a hiccup of the brain or however you want to call it. It seemed like that was her considered, she sounded like a person who was not grounded in our First Amendment jurisprudence in any meaningful way. That's the disturbing part of it.
So there's a good possibility that if this Bianchi versus Brown makes to the Supreme Court, that we might have one or more justices saying, by your reckoning, if we shut this down, then people will be allowed to own firearms across the country. And that, of course, is clearly not the purpose of the Second Amendment, is it, Scott?
It was troubling, boy.
It's a troubling thought. We'll be back with more troubling thoughts after this short break. Don't go anywhere. We dismiss history at our peril.
Liberty Nation Radio with Mark Angelides.
And we're back with Scott Cosenza, Liberty Nation's legal affairs editor on Liberty Nation Radio, heard coast to coast on the Radio America Network. I'm your host, Mark Angelides. Now, we've been running the gamut, really, on amendments today, Scott, haven't we? We've covered the Eighth Amendment, we've covered the Second Amendment, the First Amendment, three of my favorites, but there's also another one, and that's the Fourth Amendment, Scott. And that seems to be much in the news nowadays because, well, let's be fair, people are going into homes that they do not own, taking possession of those homes, and then having the full support of local police departments when saying, hey, I got to stay here as a squatter. And that seems to me to be very much a Fourth Amendment issue, isn't it, Scott?
I don't see it that way.
Okay.
It's a civil law issue.
Yes.
The Fourth Amendment is a prohibition against government action. Okay. Initially as applied to the federal government and then incorporated against the state. So it prohibits the state or federal government from doing many things, right? But this is about private action. This is about individual actors who are occupying private property, and the rightful owners of that property wish to be free from their presence in that property. So I don't know why you think the Fourth Amendment is the key implication for this.
Because the protections of the people within the house are being administered by the state. And of course, it's being incorporated through the states, right? And so the people who turn up to get the houses that they own back, they're being hauled off and charged with trespass. And that, to me, seems as though that's the state taking an intervention in what should be a civil matter.
So police officers are not well suited. Police officers are not well suited to understand who is the rightful owner of a piece of property. And what I mean by that is plenty of property in America is owned. You can imagine a case where siblings are fighting over a property that's been passed down, and a brother and a sister or cousins are saying, oh, no, I'm the owner of that. Oh, no, I am. Oh, no, they left it to me. Well, that will's being challenged. And a police officer literally called to a scene at, 9 p.m. on a Sunday night. They don't have a grounding in property law. They don't know what the hell to make of it. But if one party is occupying a property and one is not occupying it, police officers are they're classically trained to keep the peace. And so the most likely path forward to keep the peace in that matter is to say to the party challenging those who are currently occupying the structure, you need to go to civil court and get an order to evict those folks. And in the meantime, to leave them be. And I don't think, broadly speaking, that's a problem. I think that, we should encourage police officers to work to keep the police, to de-escalate, and not expect them to be lawyers, in action, basically.
Yes, to me, it seems that this idea of staying in property that you don't own, it was kind of exacerbated during the back end of the pandemic, where there was a federal moratorium on evictions.
Oh, and the clogging of the courts, Mark. And exacerbate, I think, is an understatement. Absolutely. And I would say to you, based on my statement, I don't support, squatting or squatters. And I think that governments actually have an easy solution for this, which is to create an efficient mechanism for which property owners can seek eviction proceedings. There are many jurisdictions whereby a holdover tenant, for instance, which is the classic squatter, not somebody who's sort of like lying in wait for a vacancy but holdover tenants are classic. So you pay your rent until a certain amount of time, you lose your job, you stop paying your rent, and you don't move out. That's a holdover tenant. There are jurisdictions in this country where you're going to be out that first month, basically, or maybe the second month. And then there are jurisdictions where you're going to be there for 2 years. And so because of the way the courts are handling those things. And so that's not a complaint against the executives or police power, Mark. That's a complaint against the efficient running of our courts.
The key thing is I've always felt that a country that doesn't protect property rights in a robust way is essentially a failed state, because we see this for the, all of the communism that didn't work that time, all the time before, the time before. When the state ends up not protecting the rights of property owners or farm owners specifically during the Russian Revolution, let's say, and that's really just the precipice of a state collapsing upon itself. And I think a lot of people are worried about that, especially when there's videos of illegal migrants sending out information to others saying, you can just come and get a house. You wait for it to be empty, you go in, you fake a lease. And this is going all around social media. And it wouldn't surprise me if people were doing it. It certainly seems, if it is that easy, that people are. And yet, as you point out, there's a number of states that aren't stepping in to protect people, other than say, well, you've got to go to civil court, and that could take 2 years or more, by which point, of course, people could have lost their houses.
This is why we can't have nice things. And I meant that. I understand, it's humorous, but I also meant it to distill it to its essence. Yes, if you can't protect property rights and enforce private property, you will not have a society worth defending in any way. It'll be a tragedy of the commons. And why would you pay to upkeep your property if there's a squatter in it? Why would you have the lawn mowed? Why would you make repairs? It's going to be a blight in the neighborhood. I don't think the squatters are going to be calling the asphalt company to come redo it in the springtime or the summer, like the homeowner would be. It's a great tragedy for all involved. And the blame needs to be put where it is, and the people need to demand that the courts move efficiently with these things. And so many of our problems in the kind of justice and political areas are seen mostly where there is no competition for leadership with party versus party. So whether it's a endemic Republican, never a Democrat gets a chance, or endemic Democrat, Republican cannot get a chance to win, because what happens is during the primary process, there's little incentive to reveal the corruption and malfeasance, because there are too many friends involved, and so they don't they don't argue about those main things, and people suffer.
There's no threat within a closed system. Scott Cosenza, thanks ever so much for joining us.
Thank you, Mark.
And that's all we have time for on this special edition of Liberty Nation Radio, heard coast to coast on the Radio American Network. I've been your host, Mark Angelides. I'd like to give special thanks to our guest today, Scott Cosenza, Liberty Nation's legal affairs editor, and of course to you at home for taking the time to tune in and join us on this little adventure. Thanks for listening. We dismiss history at our peril.
Liberty Nation Radio with Mark Angelides.
Don't get caught up in the media madness. Join our movement for free thinking and free speech at libertynation.com. Publishing news and analysis 24/7 with original articles by our team of authors who tell it like it is. Join us each week for online TV shows, The Uprising Podcast, and Liberty Nation Radio. We believe in free thinking and free speech. We are libertynation.com.